Ladies and gentlemen of the jury, this case is about a judge who got caught concealing his assets. The state of Ohio has charged the defendant with a couple counts of falsification. And what that means is that the defendant knowingly made false statements and knowingly swear or affirm the truth of false statements previously made when the statement was in writing or in connection with a report or return that is required or authorized by law. The state of Ohio has also charged the defendant with 3 counts of tampering with evidence. And what that means is that the defendant, knowing he had no privilege to do so, and with a purpose to defraud, or knowing he was facilitating a fraud on the state of Ohio, destroyed, removed, concealed, altered, defaced, or mutilated any writing or record. And the record was kept by or belonged to a local, state, or federal government agency. In this case, it's going to be a state agency. I'm going to talk about that in a second. Furthermore, we charge the defendant with 2 counts of soliciting improper compensation. And it's while he was a public servant, being a judge, they knowingly solicited or accepted any compensation other than that allowed by law to perform his official duties or to perform other acts or services in his public capacity, or for the general performance of his duties, or as a supplement to his compensation. And we charge him with 2 counts of having an unlawful interest in the public contract. And it's, while he was a public official, he knowingly authorized or employed the authority or the influence of his office to secure the association of a public contract in which he, a member of his family, or any of his business associates had an interest. In this particular case, ladies and gentlemen of the jury, the defendant, when he was elected to the bench in 2007, along with his wife and his business partner, a man named Michael Tully, who was an attorney, attempted, and for a while, did try to move a closely held corporation called Whiteacre North over to another attorney named Shivani Smith in a sale. The Whiteacre North LLC, and you're going to hear about, was a company that, for all intents and purposes, ran an office building that's located at 600 Broadway in Lorain. That office building, by and large, for years, has housed solely attorneys' offices. There may have been, over the years, a political candidate that rented some office space. There may have been a CPA over the year that rented office space, taxpayer, something like that. But by and large, it was an attorney's office. And when the defendant first came on the bench, there was a problem. And the problem was that as a judge, you can't have people who are renting from you practicing in front of you. All types of reasons. You're going to hear evidence that there's ethical opinions about that, and that is prohibited unless there's known involuntary waivers. But within a week of him taking the bench, representations were made that he had divested himself from Whiteacre North, and that it was now owned by Attorney Shivani Smith. And Attorney Smith, I believe you'll hear the evidence, was prohibited from practicing in front of Mr. Burge. One thing that was not known at the time, but you will see in the evidence, is that Mr. Burge, as well as his partners, were personally liable for the real property, actual building, if there was a default. So although Whiteacre North was in the name of Siobhan Smith and his wife in a 4-year contract, Mr. Burge was still the person who was responsible if the building defaulted, if there was a foreclosure. And there had been a structured foreclosure in 2001. I believe the evidence is going to show that this was not ever really a great financial venture. The Lorain County Prosecutor's Office and the defendant probably had a contentious relationship. And in 2011, something happened. And what happened was that Mr. and Mrs. Smith, in that 4-year contract, failed to be able to buy the building, essentially. And so in January of 2011, the building in Whiteacre North, by the terms of the contract, revert back. And the fortunate thing about these types of cases is that there's lots of paperwork. And there's a paper trail. The defendant, as an elected official, has to fill out what are called financial disclosure statements. Some people call them financial disclosure forms. You may hear them called shorthand because everything in government needs an acronym, an FDS. Those FDSs, the evidence will show, are government records that are required to be filled out every year by April 15th. That is a disclosure of certain assets, certain payments, things that are made to all public officials. Have to do it. That way, we know what our public officials own and what they don't own, so that there can be conflict checks. For instance, if you're in a dispute, legal dispute with a bank, and the judge owes a lot of money to the bank, wouldn't that be something you'd like to know? Not saying anybody's doing anything wrong, but that's why, the evidence will show that's why these forms exist, so that sunshine can permeate and shine a light on us, so we know what is going on with the financial health of our elected officials. The building reverted, and the LLC reverted back to the defendant. And at the very least, it happened in February of 2011. He had a problem. The attorneys that were practicing in front of him and renting from that building should have just gotten off his case. He should have just gotten off the case. He should have just transferred the case, as the evidence will show. But instead, he didn't do that. Instead, he continued suing the cases. He actually approved the payments to 2 attorneys who were renting from Whiteacre North. He actually approved payments of public funds to them for contingent service work. These attorneys, they did the work. These attorneys, I want to be very clear, did nothing wrong. And I believe the evidence will show they weren't sure at the time who Whiteacre North was. They were told there was no problems. And these attorneys did nothing wrong. But these monies came And then, of course, they're working attorneys, they're business people. They're able to then, help pay their rent. Now, you're going to see a lot of paper, and I don't want to bore you at the end of a very long and hard day with a whole bunch of it, because we're going to get to it. But as I said, the nice thing is that in these cases, there's paper. And the first thing is that the financial disclosure forms I talked about before, while this matter was being investigated, the defendant sent down to the Ohio Supreme Court, care of the Board of Grievances, and Commission on Grievances and Discipline, which are the people who hold these records, and you're going to hear from, amendments to his financial disclosure forms. And right up on the screen right now, you have his financial disclosure form for 2011, filed in 2012. And he says, I need to add Lake North. He, for the thing that was filed, in 2011 for the year 2010, it's like, I need to add Lorain National Bank. Lorain National Bank was the bank that held the mortgage, and that the defendant would have been personally liable to if the business failed and they weren't able to make the mortgage payments. The bank comes back on the defendant and the other individuals personally. So he files these statements with the Ohio Supreme Court after the investigation is ongoing. As part of the investigation, as part of the investigation and part of this, you're also going to see what's been marked State's Exhibit 19. It's up on the... And what State's Exhibit 19 you're going to hear from the Lorain National Bank shows is that the defendant was the signatory on the bank accounts through 2012. So even though Mr. Smith, during this time frame, was primarily running the business, the defendant was still a signatory on the accounts. The defendant, as I mentioned, had some disputes with the Lorain County Prosecutor's Office. And in February of 2014, there was something called an affidavit of bias and prejudice that was filed in a case with the Ohio Supreme Court. And you'll be able to see all these documents. They're back and forth about primarily actually another matter in another criminal case. But the defendant files, or actually sends, this document to the Ohio Supreme Court. And in that document, he attaches several letters. And he attaches his assignments to Mr. Smith of the LLC. It's called an assignment, which is what they executed with Mr. Smith. This assignment never was filed in any public. The mortgage was filed. Bank documents were filed. But the assignment was never filed. The bank documents, you'll see, indicated that you couldn't do an assignment. That the bank had the right to essentially demand all of its money if there was an assignment. So this assignment never gets made a public record until well after it's over. It was a 4-year assignment. And the defendant also includes a letter. And it's dated June 20th, 2011 to Prosecutor Matt. And as you can see, it says, "Dear Dennis, on February 12, 2011, the interests of Shivani K. Smith and Zura Morris Smith in a partnership known as Whiteacre North vested in attorney Michael Tully, attorney Susan Burge, and me. This occurred when Mr. and Mrs. Smith declined to proceed with the purchase of the partnership and its assets, principally the real estate located at 600 Broadway, Lorain, Ohio, with a zip code, and the various office equipment there located. On June 7th, 2011, I transferred all my interests in Whiteacre North to my wife, Susan C. Burge, excuse me. At this time, the status of the lawyers leasing the office at 600 Broadway is that they are tenants of Whiteacre North, a partnership owned by Michael Tully and Susan Burge. I no longer have an interest in the partnership or in the real estate." It goes on to say, in closing, please find an opinion from the Ohio Supreme Court indicating that it's not improper for me to hear cases involving attorneys who lease office space at 600 Broadway. The evidence will show that although Dennis Will in his office had raised concerns and had repeatedly been rebuffed about Whiteacre North and told the defendant had no ownership, that this letter never got to Dennis Will. Never given to Dennis Will. He didn't know that. But the defendant in 2014 gives it to the Ohio Supreme Court as part of this affidavit of bias and prejudice. And you'll hear the evidence that the prosecutor's office, something like this would come in and they'd know about it because of all the concern. The Ohio Supreme Court, the evidence will be, has an arm known as the Board of Discipline, sometimes called the Disciplinary Council. And it's who handles the ethics issues. Who handles the ethics issues, particularly with regards to judges in the state of Ohio. Generally speaking, those inquiries are confidential. But Mr. Burge had, because of some statements he made to the newspaper, had waived the confidentiality to it. And you will see a letter from an attorney representing Mr. Burge to the Ohio Disciplinary Council. Now coming to evidence, and in part, the letter says, as we stated in our March 29, 2013 response, Shivani and Zura Smith defaulted on the purchase of Whiteacre North Limited in February 2011. At the time of default, Judge Burge, Susan Burge, and Michael Tully believed litigation would be required in order to 1, cancel the contract of the sales to Smith, and 2, collect on the promissory note which secured the contract. It wasn't until the former owners of Whiteacre North met with attorney Robert Ellis in June 2011 that they learned that their interest in the property reverted automatically when the Smiths defaulted on the purchase. Only recovery on the promissory note required litigation. Upon learning of the automatic reversion, Judge Burge assigned his entire interest in Whiteacre North to his wife, Susan Burge. In hindsight, Judge Burge recognized he should have met with attorney Ellis immediately after the learning of the default to ensure he did not have an interest in the Whiteacre or the property. The interesting thing is that you will see documents where Mr. Burge does sell for $1 to his wife something that is worth tens of thousands of dollars, but they're husband and wife. Interest in White Acre North. That too is never filed. It's not a public document. And when I say filed, it's not filed in the recorder's office. It becomes public because he attaches it to the filings years later with the Supreme Court. Well, herein was his fatal mistake in many ways. These documents have now become public. These documents show that he owned this property, that he approved attorneys' fees on it, and you'll see that some of these attorney fees are written in June. I mean, this is all contemporaneous. That he meets with a lawyer and has a transfer to his wife of essentially a commercial building that he is personally liable for. And he doesn't list it on his forms. Now, these forms are very simple. They're very direct. There's something that any lawyer should be able to fill out, certainly any judge should be able to fill out. And they've got warnings on the back. The warnings change over the years, and you're going to see at least 3 of these forms as part of the charges where he's failed to list things, the government records. And these warnings are pretty explicit about what can happen. And this is why those warnings are on there, because this is what happens. The defendant had a problem. The evidence will show, had a ownership interest. The evidence will show by the ethics rules, would have been and should have been forced to step off the cases when he had his ownership interest. But the evidence will show he didn't do that. And the evidence you'll hear from some of these attorneys will be, listen, if I couldn't be in 1/6 of the courtrooms in Lorain County, or my cases being shuffled, you know, I'm going to need to find another place to be. They're business people. The evidence will show that, and that you'll hear attorneys, at least one attorney say, listen, White Acre North had an interest in me succeeding as a business person. And court appointments for a working criminal defense attorney are important. They're money that the government's going to pay you, and you know the government's going to pay you the money. You're not going to have to be out there collecting from clients who may be incarcerated or may be in the wind. The defendant didn't want people knowing what had happened, wanted to try and sweep it under the rug. He did a pretty good job of that, actually. But he didn't remember, I believe the evidence will show, or didn't learn, cover up this person. Because you will see, and have seen, that the defendant tried to modify his answers. So we've got the evidence will show, we've got 2 competing answers to these forms. In these years he said this happened, and then in 2014, after the investigation started, oh no, you know, my mistake, you know, but it wasn't a mistake. And the evidence will show that. I thank you for your time.
All right. Burge?